which was while our constitution does speak about the Constituent Assembly of the state of Jammu and Kashmir, which was then in contemplation at the date of our constitution on 26th of January 1950. Significantly, after 26th of January 1957, our constitution does not speak of the Constitution of Jammu and Kashmir at all.
Milord, I'll say, Milord, with great respect. The reason being that the Constitution of Jammu and Kashmir, Milord, was a product which was envisaged because there was a Constituent Assembly. But the way it has happened is the Constitution of India, Milord, the applicable provisions were brought into the J&K Constitution, and the J&K Constitution, Milord, had its own chapters, which I have pointed out for your Lordship's consideration, therefore, establishing its framework.
Our Constitution speaks of only one institution, namely the Constitution of India, and the Constitution of India as it applies to the state of Jammu and Kashmir, subject to modifications and exceptions.
That's right, Milord.
Therefore, the only document, the only compact, or the only basic document that is within the contemplation of our constitution is this constitution itself.
I agree. But, Milord, now the question is, was J&K Constituent Assembly not tasked with a framing of a constitution? That is clear from sub-article 2 of 370. Under 372 and 3, Milord, if your Lordship sees both these articles.
Post 1957.
Yes.
Post 1957, neither the government or the legislative assembly of Jammu and Kashmir, nor for that matter, the political establishment in the rest of the country represented by Parliament, nobody ever thought of amending the Indian Constitution to bring the Jammu and Kashmir Constitution expressly within the fold of the Indian Constitution.
My Lord, it may not be necessary. I'll tell your Lordships why, if I can, my Lord, if I may humbly urge, for your Lordship's consideration. The Constitution for Jammu and Kashmir is intended to be applicable to the state of Jammu and Kashmir. But it is a constitution because it is framed by a Constituent Assembly.
But
Lord, there could be.
The Constitution of Jammu and Kashmir imposes limitations on the power, on the executive power of the Union and on the legislative power of an organ of the Union, namely Parliament.
The Constitution of J&K doesn't impose any fetter.
The Constitution of J&K refers to the fact that, the residuary power would be vested with the...
Yes. Just forgive me. I'm obliged.
That is a clear fetter. I'm just giving you one example of the fetters. But therefore, there are fetters in the J&K Constitution on the operation of the Union Constitution.
Well, this is actually the asymmetry.
It was not necessary after 1957 for the Constitution of the Union, which was now the only constitution for the entirety of the country, including Jammu and Kashmir, which had acceded to India. Was it not necessary for the Indian Constitution to be amended to recognize some other constitution as an intrinsic part of this constitution?
Well, what they did was, in the order, 54 order, I'm answering, my Lord, the Chief Justice's question as an example. I'm answering the question, my Lord. If your Lordship sees the 54 order, the subject of state lists was omitted in its application. So what we have done is, with the help of the 54 order, we have imposed fetters on the Constitution. Well, that's the point for your Lordships to consider. The 54 order, by saying that under Article 246, only Article 1 will be read, 2, 3 and 4 were initially, my Lord, omitted in the 54 order. Subsequently, my Lord, 3 and 4 were omitted. Only 1 and 2 were retained. And, my Lord, in the lists, namely in the 7th schedule, the state list was completely omitted. It has been omitted, my Lord, in the order itself. So what I'm submitting is, when your Lordship said that there is a certain degree of denudation of power which otherwise is available under the Constitution, like, my Lord, say for instance, entry 97, my Lord, entry 97 of list 1. But entry 97 of list 1 was in the 54 order deleted. But in their constitution, they have said whatever is the domain of parliament, whether it is in the concurrent list or in the union list, it is entirely for parliament to frame laws. The rest of it will be the residuary powers of the state legislature. So, my lord, this is what I meant, that the two talk to each other. The orders, that is, my lord, 370 orders and the Jammu and Kashmir constitution, they both speak to each other. As your lordships rightly said, there are some carve-outs for Jammu and Kashmir. But those carve-outs, my lord, are volitionally done. Those carve-outs in the order of 1954, by giving them this sense that you have freedom to legislate in your spheres, was a conscious carve-out. That is the point I'm making.
But that's the problem, Mr. Subramanian, because as you rightly said that these were volitional carve-outs. So, just as the union has therefore issued those COs, right from 1950, 1952, 1954, unless there is some higher constitutional precept which prevents them from modifying that carve-out, what is there to restrain the union from modifying the terms of that carve-out?
Well, the
Unless
answer
we were to make the Jammu and Kashmir constitution a part of our constitution to impose fetters on the power of parliament or the executive.
my lord, may I answer?
Otherwise,
My lord, may I endeavor to answer?
It is about concurrence.
Yes.
Concurrence and consultation, and then you have to decide whose concurrence was required in a state at a point of time
Yes.
when 356 is in operation. If you accept your argument,
yes,
during 356, the operation of 356, you cannot exercise under the second proviso to Article 371D at all.
yes, that is my lord.
Then you're home. You're
Yes.
home completely.
But my lord, I want to
accept that
yes.
during the time that the power of the union under the second proviso to Article 370D is not denuded when 356 is in operation. In that event, the union was clearly within its power. For instance, suppose 356 is in operation. All the executive powers of the state are assumed by the union. Who issues an ordinance in the state?
Lord,
An ordinance has to be issued in a state.
Yes.
Any state, state A of the Union of India. Powers under 356 are assumed by the President of India. Urgent circumstances arise and an ordinance has to be issued. Can the President not issue an ordinance for the purpose of that state?
My lord, the difference is between, my lord, a power to make laws. I'm submitting for your lordship's consideration. A power to make laws. Yes. Lord, I wanted to answer your lordship's observations in a serial order. The first is your lordship's asked about the Jammu and Kashmir constitution being absent. It is not, my lord, it is absent. It is actually, there is a recognition of the position of the constitution because many parts of our constitution under the 54 order were not applicable to the state of Jammu and Kashmir. That's the first. The second is, my lord, the Jammu and Kashmir itself has fundamental features, is acknowledged in a passage of Chief Justice Sikri in Keshavananda Bharati's case. I'll point it out. Thirdly, as far as, my lord, the power under Article 356 is concerned, it is conditioned, my lord, for a certain purpose. Your lordships have already heard submissions on it. Article 370, my lord, does not, it is completely alien to the purpose of 356. Article 370, my lord, is a case where there has to be bilateralism in the very nature of things. If your lordships were to read the transposition of power in the governor and in the president, then, my lord, the net effect is that even though Article 370 begins with a non-obstant clause, my lord, it will be rendered nugatory. My lord, the reason why special powers are there are only when they are conditioned by emergent needs. The scope of 356, my lord, is emergency. And, my lord, it is well settled. even whatever is done during a president's proclamation in 356 cannot be irreversible. It cannot be final. My lord, that is why it is an interim arrangement for the continuance of the Constitution under 356. Under 356, my lord, it is not intended to be a reservoir for power for actually exercising powers under the Constitution which have nothing to do with emergency. They have nothing to do at all. Then, my lord, I say that 370 is outside the ambit of 356 because it is not germane to the purposes of 356. And 370 contemplates and in my respectful submission, my lord, 370 contemplates limitations on that power. These are, my lord, express limitations. And these limitations, my lord, cannot be obviated by taking recourse to 356. That is the point I'm making.
Yes.
These are, my lord, express limitations. So, my lord, I submit with respect 370 also, my lord, is a power which is coupled with a duty. And the obligation, my lord, under 370 is to act consistent with the very purposes of 370. And the very purpose of 370, my lord, was to enable another assembly to take a decision, and both of them, my lord, work together. That is, my lord, the scheme as far as 370 is concerned.